Hi everyone, and welcome to week 5 of Reproduction and the Law. Last week we talked about striking the balance between First Amendment religious rights and reproductive rights, issues such as when does a pharmacist or healthcare provider have the right to refuse to provide reproductive health care if doing so runs afoul of his or her religious or moral beliefs. This week we're going to jump into the area of what to do when reproductive rights and First Amendment speech rights collide. And this can come up in a lot of different areas. We'll talk about a few. One of the first is the issue of protests outside of clinics that provide abortion services. I'm sure you have all driven by a Planned Parenthood or a clinic that is known to provide abortion services and seen a protester or a group of protesters outside. These protests can range from protesters silently praying, to having signs, to having fairly graphic signs, to engaging in clinic blockades, and at the most extreme fringe of sort of the protesting movement, actually engaging in violence and destruction against abortion providers, clinic staff, and the buildings themselves. The question is, where on the spectrum of speech do we want to draw the line? It's pretty clear that if someone is actually engaging in violence against an abortion provider, that's going to run afoul of many federal laws. But what about pure speech? Let's think about some examples. I had you read the Supreme Court case Madsen that deals with the issue of buffer zones outside of clinics. Can there be a zone around a clinic that provides reproductive health services into which a protester cannot enter, based on the idea that women should be able to walk into clinics unimpeded? Healthcare workers should be able to walk into clinics unimpeded. And look at how the Supreme Court dealt with the competing interests here. The reproductive rights interests of going into a clinic to access reproductive health care, and the speech interests at play, and try to figure out whether the court struck the right balance. Moving out of the pure speech realm, there is the issue of violence against abortion providers. We know this is still going on. This was in the news just last week that Dr. George Tiller was murdered as he entered his church on a Sunday morning. He is not the first abortion provider to be murdered. The National Abortion Federation, which has been collecting violence stats for about 30 years, estimates that from 1977 to the present, there have been over 6,000 incidents of violence at clinics, and there have been 8 murders, with Dr. Tiller being the 8th. Question is, what are the ways to deal with this? One of the federal protections is the Freedom of Access to Clinic Entrances Act, otherwise known as FACE. And what FACE does is it subjects anyone who engages in force or threats to stop a woman or a healthcare provider from entering a clinic. It would subject them to federal criminal penalties. So this is federal legislation enacted into law in the mid-90s that does create an additional penalty for impeding access to a healthcare clinic. One of the new questions is, how far does FACE go? There was a recent case out in the Ninth Circuit dealing with speech issues and FACE. There were a group of sort of extremist pro-life advocates who were doing things like putting wanted posters of abortion providers up on the streets, providing abortion providers home information, providing information about abortion providers' children, where they go to school. And some of them had to put up something called the Nuremberg Files. It was a website available on the internet. And the Nuremberg Files listed the names of abortion providers, clinic workers, advocates, judges, and basically created a hit list. If the abortion provider or anyone on the list was injured, their name was grayed out. If they were actually killed, their name was crossed out. So it was very much a hit list of abortion providers. And the court had to deal with, is this just pure speech, or does this go further and run afoul of FACE? See what you think. I've actually put on Blackboard a link to the Nuremberg Files website. I'll tell you that it is fairly graphic. So don't watch it, or don't look at it for around children, or anyone who you think might not want to view the site. It's a pretty graphic site. Look and see what the site says about Dr. Tiller, who was recently murdered. Figure out whether you think this is just pure speech. It might not be speech we like. It might be speech that we disagree with, but is it speech, and does it deserve First Amendment protections? Where do we strike that balance? Switching gears a little bit, another issue where speech and reproductive rights have been colliding as of late is with the issue of crisis pregnancy centers. I'm sure some of you have heard of this issue. Crisis pregnancy centers are health centers that do not provide abortion services. That, of course, is all fine and good. As we learned last week, no one has to provide abortion services if they don't want to. The issue that has arisen is with the advertising of some of these crisis pregnancy centers. And I say some very deliberately. I don't mean to imply that this applies to all crisis pregnancy centers. Some of these clinics have been engaging in what is arguably misleading advertising, doing things like listing their clinic under abortion in the phone book. We've all seen the signs that say, pregnant, need help, we provide all options, and then list a phone number. The question has become, if clinics, CPCs, crisis pregnancy centers, are advertising in a way that makes women think they are providing abortion services, is that misleading commercial speech? And is that something that we can prohibit? Now, you can see where this can be a tricky area. Is simply advertising under abortion in the phone book misleading? How far would a crisis pregnancy center have to go to actually be misleading women? And is this potentially misleading speech deliberate? I've posted a piece of federal legislation on Blackboard, the Stop Deceptive Advertising About Women's Services Act. And this is a piece of federal legislation that was introduced but never enacted into law, attempting to deal with the issue of misleading speech of crisis pregnancy centers. See if you think the act strikes the right balance. Does it provide sufficient protection for the speech rights of small businesses that might want to advertise? And then I've also posted the website for a crisis pregnancy center. And I want you to look at that website and figure out, is this a website that would fall under the reach of the act I posted on Blackboard? Is this website misleading, or is it simply pure speech? I think that this is not one of the extreme websites. This is one where there could be some gray area. So I'm interested in your thoughts on striking, again, the right balance between reproductive rights and speech. I'll see you on Blackboard.